Folks, we are live in Fulton County, Georgia for the case against former President Donald Trump and about 14 of his associates that remain in the RICO action against him. These arguments are based on First Amendment grounds, saying, hey, anything said by these defendants was protected speech, you know, that First Amendment thing, and therefore not actionable, therefore the case should be dismissed. Doing most of the arguing is the attorney for Robert Cheeley, who is a former attorney of Donald Trump. We're going to go back into court and listen to more of his arguments. This case joins a number of the defendants. So you've got one doing the heavy lifting and the others join in. Therefore, everybody wants to be bound by the same ruling. Here we go.
The dissent urges that in considering Hall's vagueness challenge, which we understand to be the First Amendment challenge there, which would echo or mirror our First Amendment challenge here on freedom of speech, we are limited to the allegations of fact appearing in the indictment. What this means to me, and I'm suggesting to the court, is that all 7 justices were in agreement that you can take the allegations of fact in the indictment and make a determination of an as-applied constitutional challenge. The dissent's only issue was other facts were being considered. We don't want other facts being considered. We are more than willing and have indicated on the record that we will agree for purposes of a First Amendment challenge that the allegations, averments, facts in the indictment are to be taken as true for purposes of that challenge and that challenge alone. It's exactly what Hall suggests. It's exactly what 7 justices would have agreed on based on the footnote number 2. And therefore, we ask the court to find it ripe to be considered. If additional briefing then becomes necessary, once the court deems it appropriate to consider it as applied, both sides can present our position to the court, much of which has already been done so by co-defendants counsel. But then we can issue briefs and the court can determine law based on the allegations in the indictment as applied. Thank you.
And so, Mr. Sadow, on that point, I would say that one of the goals and purposes today is to complete our record on these issues. So I think that if your or any other co-defendant's intention is to make a as-applied challenge firmly under the facts as averred in the indictment, this would be the time to do it. So not right now, but through briefing.
I was going to say that might open
this
up
in the pretrial stage. Yes. All right.
How much time would you give us to do that, sir?
I wonder if we could stay on the same briefing timeline as we had with Mr. Schaefer's counsel.
I believe that was 10 days.
No, I think it was a little bit longer than that. We had the state replying in that instance on the 15th, and then any rebuttal or surrebuttal, whatever we want to call it, by the 2nd.
It seems appropriate. Everyone agree?
All right.
Just to be clear, is that?
I think I think they would be going first, since he's saying that they are doing a more specific as applied challenge based on the facts of this indictment, and then the state would have the ability by the 2nd to respond. I recognize that that is a time when most folks are off. So if the state needs more time and wants to ask for it, we can take it up then.
Okay. And Judge, just to be clear, would those supplemental briefs also include the issue of ripeness? Any additional argument on the issue of ripeness?
It can include whatever you want it to.
Okay. Thank you.
Sure.
And if the court will permit, we'll try to do one consolidated brief if that's agreeable to all counsel.
Sounds good.
Thank you.
All right. Let's transition over. I believe we should have, we had noticed for counsel for Mr. Meadows and Mr. Clark. I don't know if they were appearing they're both in person. All right. Is there any way we could make some room at council? I know we're a bit tight here, but. Okay, well then there you have it. We're going to start with Mr. Meadows. All right, sir, if you could introduce yourself for the record.
Yes, Jim Durham for Mr. Meadows. And Judge, for the record, I think I need 90 seconds.
Okay, and your client has waived his presence here today?
Yes, sir.
All right.
Simply, Your Honor, we're just asking for an extension of our deadlines. The 11th Circuit has taken, Mr. Meadows believes this case, as it relates to him, should be in federal court. I know we have deadlines of December the 4th, as it relates to discovery. We have deadlines as it relates to pretrial motions on January the 8th, and we've asked simply for an extension as it relates to discovery, February 1st, 2024, as it relates to motions, March the 1st. 11th Circuit has taken this on an expedited review or argument on our appeal is December the 15th. We're hopeful that the 11th Circuit, based on their expedited review, is going to have an opinion within a month or two. And for that reason, we'd rather not be litigating in two separate court time. Don't think it's going to prejudice the government. As it relates to other trials that have already been set involving co-defendants, federal case up in DC, federal case down in Florida, and even the DA's office has suggested a trial in August. And I know Your Honor has contemplated the possibility of multiple trials in this case as it relates to, severing particular defendants and trying them separately. I don't think this is a big ask. Don't think it prejudices the state at all.
So just to be clear, unlike Mr. Clark's motion, it's not so much you're saying, hey, we don't have the bandwidth. It's we just would rather be doing this where we believe the case ought to be.
Yes. If we win in the 11th Circuit, it's a clean slate. It's going to preserve some of your resources for sure. So you wouldn't have to rule on any of the motions that we file. We anticipate we would file a number of pretrial motions. And if you rule on them and we go to 11th Circuit, then the slate's going to be clean.
The motions you would file, though, I guess with the exception of supremacy clause issues, wouldn't they substantively be very similar to what you'd need to file in this case?
Yes, they would.
You'd be maybe making many of these same First Amendment issues.
Well, we've actually adopted some of the motions. We're not asking you to hold up as it relates to the motions that they have filed, but we do believe we're going to have some unique issues to raise with the court.
Okay. All right. Thank you, Mr. Durham.
Yeah.
Let me hear from Mr. Clark's counsel, and then I'll respond here.
Thank you very much, Your Honor. It's Harry McDougall for Mr. Clark. And there is
Okay, let's talk about that tentacle of this octopus we're dealing with here. This was the attorney for Mark Meadows, whose name may be familiar with his connections with the White House and former President Donald Trump. He tried to get his state-based case removed to federal court. Denied by this judge. They have now appealed that to the 11th Circuit, and they expect to get a decision in the next couple of months. So what counsel for Mark Meadows is asking is that his deadlines, he had a discovery deadline of December 4th, next week, wants it pushed to February, basically saying, let's let the appellate court make a decision here. Because if the case is going to come back here, then we're already into some deadlines, or we're past deadlines we would have violated. On the other hand, if the court rules in Mark Meadows' favor and this is removed to federal court, then we got a new dance, and we're starting all over with the federal court. So Katherine Lizardo is here, Fanon Rucker here. Guys, an interesting wrinkle. Let me start with you, Judge. What do you think about the removal to federal court of the Meadows case or any of the other defendants?
Motion that was not unexpected. These are all things that were related to a federal election. And the argument they made is, well, because this involves federal positions and a federal seat and a federal election, it's not appropriate for the state to be able to make decisions about it. The judge neatly denied that because these are not federal charges, they're state charges, even if the actions were related to something that had to do with the feds. So I think it was, not an unexpected motion. There's all kind of motions flying around this case because people have a lot of money in this case to do that. But I think that the decision was appropriate. And I'd be surprised if the 11th Circuit does anything different than what the judge ultimately ruled, and that is that these are purported violations of state law, and that state court is the appropriate place for the charge to be heard.
Yeah, and Georgia has adopted their own version of the federal RICO statute. And I think the bottom line is these things are what will drag this case into 2025. That's what I think is ultimately the upshot. Let's take a break here because we were kind of long in that hearing. So stand by, Katherine. We'll get to you in a moment. We'll come back right after this.